Lady from 18.
Thank you, Mr. Speaker. I wish to debate against the memorial.
The lady has the floor to debate against the memorial.
Thank you. I feel compelled to rise because there is so much talk of the Constitution, and I think the Constitution is an extraordinary document. I came late to the Constitution. I was actually born in Canada, but I moved down here and I fell in love with the document, and I think it's one of the most amazing things that mankind has ever created. It's the oldest document that's the founding document of any nation. And I have a little theory as to why. I think it's not so much about the democracy piece. Lots of nations throughout history have found democracy. There's no brilliance to a system of mob rule. In fact, in a default scenario, mob rule is kind of what you get. I think what's really amazing about the Constitution is its provision against tyranny of the majority. Now, and I think that's really where the judiciary comes in. They are the guardians against tyranny of the majority. Every other branch of government is majority control, right? Congress is majority control, presidency is majority of control, but there's this one sliver that is there to be the guardian, to make sure that that majority doesn't run roughshod over the 2% that's out there. The 98% gets everything else, but the judiciary is there to stick up for the 2%. And that's why the Constitution provides for lifetime appointments for federal judges, so that they never have to be beholden to the populace, so that they can stand for the 2% and not be run roughshod over in the next election, that they can take the unpopular viewpoints, that they can stand up for the little guy and not have to go face the voters at the end of the day. And they're it. They're what we have. The judiciary is all we have to stand for the rights of that sliver of minority. And in this case, I see that's what the judiciary's done. And so it feels profoundly inappropriate to me for the majority to come into the judiciary and say, how dare you stand for that minority? How dare you go against the wishes of the majority? That's exactly what they're there for. That's exactly what the Constitution was drafted to make sure they're there to do. So I think we're tearing at the very fabric of what makes this country work when the elected bodies come in and pounce on the judiciary for standing up for those rights. And, you know, historically, I think that is, you know, the Supreme Court's been doing this for quite some time, and federal courts have been doing this for quite some time. And that's how we got Brown v. Board of Education. That's how we got rid of segregation. That's how many folks on the receiving end of majority discrimination have gotten their rights. And the gentleman referred to his ancestors that were an oppressed minority. And I have ancestors that were part of an oppressed minority. And there have been many points in our nation's history where we should thank our lucky stars that we had a judiciary that was willing to stand against majority will. And I think we're tinkering with that power in dangerous ways when we criticize them and seek to impeach them for doing so now. So with that, I ask for you to oppose this.
Is there further debate? Gentleman from 29.
One stand for a question.
Will the gentleman from District 7 yield to a question?
Yes, I'll try.
Gentleman yields.
Mr. Gentleman from 7, would you tell us which judge or judges you wish to impeach?
Good gentleman, could you repeat the question louder, please?
Mr. Gentleman, could you tell us which judge or judges you wish to impeach?
Gentleman from 7.
Thank you, Mr. Chairman, and good gentleman. Yes, that's a pretty easy one. Every judge that votes against the original intent of the Constitution, because that is how our Constitution evolves till we end up with a different form of government. And I'm afraid we're already way down that track, and I think it's time we tell them no more. You've got to uphold the Constitution. And so all the judges that vote that way should be examined, critiqued, and then impeached, in my opinion.
For gentleman from 29.
Could I follow up?
Well, I'm going to caution the body on argumentative type questions. If we're in search of information, that's one thing, but if it's to be argumentative, then that might be another. But will the gentleman yield to another question?
Yes.
The gentleman yields.
Mr. Speaker, might I ask if the gentleman from 7 would include Earl Warren, for example, Justice Earl Warren, if that's an appropriate question. If not, I'll just debate the issue.
We'll defer to the gentleman. The gentleman may answer the question if he chooses.
Yes, Mr. Speaker, I will answer. I believe it was Earl Warren's court who ruled to take the prayer out of schools, for an example. And we pray here every day almost. We say the pledge, we're a nation under God, one nation under God. So when you take the Christian prayer out of school, as long as it's a generic prayer and it's not specific against any particular denomination, because our freedom of religion thing was to deal with denominations of religion, not whether we're Christian or not. So I think, yeah, a judge does that. And if it would have started with him, we wouldn't have judges out of control today. So I wish it would have started with him. And by the way, Eisenhower, I read a quote from him who said the biggest mistake he ever made was appointing Earl Warren.
Okay, that will be about enough. The gentleman, does the gentleman wish to debate the memorial?
Yes, Mr. Speaker.
The gentleman has the floor to debate.
And members, this resolution calls for an impeachment of federal judges. While it may be worthy of the press or headlines, and has been, I take it as a direct attack on the third branch without foundation and should be rejected. Presumably, the opponents to a certain ruling by the court as being activist or outside the Constitution or the original intent and not being inspired by God or whatnot, I think bring forth a baseless argument or perhaps a misunderstanding. The proponents in this case rely on the First Amendment, the right of free speech, for example. If one argues that that was part of the original Constitution, they would be wrong. That was an amendment. The original Constitution, the original intent, was not set forth in the many, many amendments that came forth after. In fact, the Idaho Constitution has had 40 amendments to the original, which may come as a surprise. To say now that we should rely on the original document doesn't take into account, Mr. Speaker, that the same has been amended these times. The original, you've heard these arguments, but to remind the body, if we were to adhere to the original Constitution, we would have to forget that it did not grant women the right to vote. We would have to forget that black minorities were not treated as humans. My personal experience has some bearing on my feelings, if I can get into that just briefly, Mr. Speaker. It makes not come as a surprise, but in representing clients, if a judge were to rules for you, like they did when I defended the Ten Commandments case in Bannock County successfully, when they rule, and that was a federal judge, when they rule for you, you think, what a wise person adhering to the intent or the constitutional principles. But if it should ever happen, they rule against your client, the same judge, perhaps even on the next day or the next week, you think to yourself, I don't know if I can say it as a member of the officer of the court, but you think to yourself, on the question of wisdom and whatnot, independence, you wonder. And you say things in the privacy of your office about that. So federal judges, as you know, are appointed by the highest representative of our land, the president, appointed by the majority of all the people, regardless of stripe or background. And then brought in and approved by the second branch, the U.S. Senate. My concern about this whole issue, and I'll be brief, my concern is the lack of respect and the concern that the citizenry has about our institutions here, our institution in the elected officials, our institution in the government, our institution in the courts. And I think this sort of love letter, if it's what it is, does not promote respect that we all need for our system by the people we represent and work for. And I think we need to ensure continued respect for the bench and the independence of the judiciary. On the impeachment of Earl Warren or that sort of situation, he ruled in favor of minorities in Brown versus Board of Education. I think it was 1954. And in hindsight, I'm sure no one would think he should have been impeached. I applaud the frustration of the proponent and the disdain for a given ruling by our court system, by a given ruling. Redress of grievances is the American way, but an attack on our institutions and our foundation without merit does not advance the necessary respect that binds us all together. This well-meaning resolution voicing frustration is understood but should be summarily dismissed and not transmitted further. That is all.
Is there further debate? Good lady from District, oh,
Thank you.
I assume the gentleman is finished. Good lady from the back row, I can't see the number. The
19.
Lady from 19 has a floor to debate or ask a question.
Mr. Speaker, I rise to debate against the memorial.
The lady has the floor.
I take a little different stand than my colleagues. I'm taking more of a heartfelt stand today. As someone referenced, this really doesn't feel like a love letter to me, and it leaves out my neighbors, my friends, my family, the people in this state that in October were granted the legal right to marry and have the same rights as other people in our state. And it continues to say that certain people who are not specified as good enough don't matter. And it matters a lot to their self-esteem and who they are and how they go about their lives. We've talked a lot in this session about discrimination of people. And I'd never think, and I think in this, the good gentleman said he didn't read the whole memorial because we already know where we are with marriage. Well, I don't agree with that. I don't know where we are with marriage. And I don't agree with what was stated in this memorial about marriage. And it talks about procreation. What about people in heterosexual marriages that can't procreate? What does that say about the worth of that woman? It doesn't feel good. We all deserve to feel a part of a system and feel like we belong and that we matter. And we should not spend time on memorials that further divide us. And I would ask just to put your heart in that place. I think the arguments about the legal aspect have been quite compelling, but just the heart of our friends and our families and our neighbors, and to give them equal footing, and not to say they don't matter or less than in our state. Thank you.
Is there further debate? Gentleman from 28.
Mr. Speaker, I agree that this is a very interesting memorial. It's one that is, as you look at it, you think, wow, what are we doing? But the reason that I think it's justified is we have a small group, a panel of judges, and I concede that their responsibility is to interpret law. But the thing that bothers me is that small group of judges are ignoring the will of the people from several states. That is what concerns me, and I feel justifies a yes vote on this memorial. Thank you.